day, and welcome to our discussion on strategies for building an IP portfolio in the life sciences sector. My name is Lisa Thorne, and I am a partner in Gowling WLG's Vancouver office, and my practice focuses on patent prosecution and patent portfolio management. Presenting with me today is Jade Wood.
Thank you, Lisa, and thank you everyone for tuning in. My name is Jade Wood. I am an IP lawyer, a patent agent, and a trademark agent based in our Vancouver's office. My practice focuses on the strategic creation, development, and commercialization of IP assets. One thing perhaps is interesting about me is that prior to becoming a lawyer, I was trained as a microbiologist. And because of my science training, I enjoy collaborating with life sciences companies to create business value by leveraging their innovative creation.
So today, Jade and I are going to discuss 5 practical tips for building an IP portfolio for growth. So let's discuss our first tip. And what this tip is to implement an information management system to protect the valuable confidential information, know-how, and trade secrets, and to address ownership issues, particularly early on. So Jade, what do you have to recommend to companies in the life sciences sector relating to this tip?
Oh, 100%. I think we are 2.5 years into the COVID-19 pandemic. The value and importance of life sciences and biotech sector has been highlighted tremendously. And really, this sector has been the center of research and development efforts in responding to the pandemic. The value of IP is more apparent today compared to ever before. So when we think about IP protection and how we go ahead and obtain IP protection, it goes to the bottom of it. IP, intellectual property, is essentially the creation of the mind. And the core of IP protection starts with the creation, management, and protection of valuable information. Before a company is able to turn valuable information into IP assets, it is really important to protect the confidentiality of such information. So here it's important to have proper non-disclosure obligations in place. And Lisa is going to talk about this later on. Patent is quite important when it comes to life sciences invention. And in many countries, the patent system has a first to file system, and many countries may have what we say absolute novelty requirement. So if someone, inventor, goes ahead and disclose his or her creation, then in some jurisdictions, patent protection may no longer be valid. So NDA, I'm sure all of you have heard of it and used it in the past. NDA is a valuable tool to protect the valuable information that your company owns. And the second issue is, if possible, it would be really great to address IP ownership issues early on. Here, the basic premise is that the inventors are the first owners of the inventions. And similarly, in the context of copyright, authors are the first owners of copyrighted works. And obviously, there are exceptions. So in the context of copyright protection, an employee's copyrighted works are usually owned by the employers. Now, when it comes to IP ownerships, if we don't address those issues early on, we may run into a situation where many collaborators come together and create something jointly. And joint IP ownership can be very tricky. Usually it really gave rise to complex legal and strategic issues. And also between different countries, when it comes to jointly created IP, the laws can be very different. For example, in Canada, subject to contrary written agreements between the joint owners, one owner cannot dilute the other owner's IP interest. This may mean you can assign your IP rights to a third party without consent from your co-owners, but you cannot grant any license agreement to a third party without first obtaining consent from your co-owners. In the United States, the laws can be different. So it's really important, if possible, at the beginning of a collaboration project, all the parties come together and to address IP issues early on. There are so many different types of IP protections, and Lisa already talked about this earlier. And now let's just go back to really the key of today's topic, IP protection. Lisa, what are some of the IP protection types of IP protection that life sciences companies should be aware of and deploy when applicable?
You know, and there's a wide variety. We have various forms of IP protection listed here. So patents, trade secrets, trademarks, copyright, plant breeders' rights for those working in agricultural industries. And, you know, a lot of this can also tie into your brand and protection of your brand as you move forward. But one of the initial decisions that growing life sciences companies come to us with first is, do I need to file a patent application? And this can, a robust patent portfolio can really set the foundation for a trajectory of growth. However, as with anything, it's not necessarily a slam dunk for when a company is looking at where they're at and where their finances are. You know, so it's a very common question. Someone will pick up the phone and call us and ask, do I need to go through the process of patenting our technology, or can we keep this as a trade secret or as confidential information within the company? And the answer here is to weigh the pros and cons of each, and you have to decide how each fits into your overall business plan. And that's a theme that we're going to circle back to a few times today, is about your business plan. The advantages of patents are that they are an asset that is very attractive to potential investors, potential collaborators, and potential licensing partners. And for a company looking to grow, entering into relationships with these potential partners is key for growth. We certainly saw that during the COVID-19 pandemic and the development of vaccines, how important cross-licensing agreements were between various companies to deliver vaccines as quickly as we did. A further advantage of patenting is enforcement. What scares people off about filing a patent application? The initial cost can be of concern. Another issue is that filing a patent application requires a full and frank disclosure of the invention. And this can be an intimidating proposition for a company that has spent significant time and resources and put a tremendous effort into protecting their confidential information, and then having to disclose it all can be difficult. You know, we don't have to disclose everything, but you have to disclose enough information in a patent application to ensure that somebody else who works in the field can make and use the invention. You know, with these concerns about patenting, many companies will perhaps want to keep their technology as a trade secret within a company. The advantages here are an immediate cost savings, and we'll touch on what some of the long-term costs can be, and simplicity in terms of, okay, we just have to have confidentiality agreements and non-disclosure agreements. However, there are a number of difficulties that can arise, particularly as a life sciences company is growing. They will need to enter into relationships with contractors and subcontractors and various partners, and ensuring that all of those entities sign a confidentiality agreement to your liking can be very difficult. And, with a lot of change and a lot of growth happening, it's easy to miss a confidentiality agreement. It's not unheard of. Another issue is, if your competitors are watching what you are doing, if they get a hold of your product, can they reverse engineer it easily? If a competitor can easily reverse engineer your product, then maintaining it confidentially within the company and not filing a patent application, that competitor can just go ahead with what you have put in significant resources into. And what happens even if you have all the confidentiality agreements and non-disclosure agreements? What if there's a breach? What if somebody says something by mistake, or something happens? Your remedy available is breach of contract, and that process of going through the claim of breach of contract is not nearly as advantageous for the technology owner as being a patent owner. And being a patent owner, should there be an infringement by a competitor, it's a very different remedy system, and quite often will result in a settlement or a licensing agreement or what have you. So you're still receiving benefit from your patent filing.
For sure. I think the key message is there are so many different types of IP protection. And when it comes to building your empire, when it comes to building your IP portfolio, I think it's important to go back to the drawing board, in the sense, really take a look at your technology platform and think, have a strategic discussion internally and think, okay, which types of IP protection are applicable, and often they can overlap. And then, like Lisa said, for certain aspects of your technology, if reverse engineer is quite simple, then patent protection would make more sense. Versus on the other side, if something no one will ever be able to solve as to your really your secret sauce, like KFC's secret recipe. And if you have the infrastructure internally to protect your valuable IP information in that case, then trade secrets protection can be really valuable, since it can last forever as long as you can keep your secret sauce a secret. Lisa, I know we talked a lot about patent protection. And I think for the life sciences sector, patent protection is really important. So here are two questions for you. When and how should a life sciences company pursue patent protection?
There's a great saying in the patent field, and we have it up there, that it's never too early to file a patent application until it's too late, such that your competitor has filed their application first. And there's so many considerations that go into the determination of when to file. And as you had mentioned earlier, most patent systems around the world operate on a first to file system. So what that means is that the patent rights will go to the company that files their application for the technology first. So what that essentially sets up is a race to the patent office. However, and especially important in the life sciences sector, and we're seeing this in policy decisions as well as court decisions, is that the patent application needs to contain enough data to show how the invention works. And I know I mentioned this previously, but it's a very important point that we see lots of patent examiners saying that, your patent doesn't have sufficient support. A common question I get on this is, does the data need to be in vivo? And the answer there is no, you don't need to have in vivo data, but you need to have some data that allows someone who works in the field and has, the common amount of knowledge as they would have in that field to make and use the invention. And another common strategy that I think a lot of our audience will have seen is, you'll see companies, they'll file a first application that is extremely broad, that covers a huge amount of terrain in the field. And then you'll see them subsequent filings where, it's the application itself is much narrower, and it may be directed to certain elements of formulation or preparation. And that's a common strategy that we'll see, a first filing that's very broad and then narrowing down to specific technologies. And so, knowing the success of this strategy when you're drafting an application, it's extremely tempting to throw in, every alternative and variation that you can think of. And this is well-founded. But be considerate when doing this, just in case some of those elements that you're putting in, are you going to be conducting specific research to that area? Do you have projects ongoing, or in the next year, are you going to be generating data directed to that element of the invention? Because it may be, you may not want that disclosed quite yet. You may want to flesh out the data on that point a little bit more, and, have your first filing and then follow up with a second filing when you've got a bit more data. So it's a lot of dialogue between various stakeholders in the company, and keeping an eye on what your competitors are doing as well. During the COVID-19 pandemic, it was a race to the patent office. You have a lot of companies working extremely hard, and they will file applications as soon as they can. In other areas, the growth is slower, so you don't see as quick as a number of patent filings. So, keeping an eye on your competitors, knowing what they're doing is important. And I think that ties into our tip number 4, which relates to some more specifics about what your competitors are up to. And Jade, I think you have a few comments on that.
Yeah, for sure. I think here the key message is be strategic, don't be reactionary. So tip 3 and tip 4, they're somewhat related in the sense searches can be very useful. It is a useful tool for you to sort of decide on a pathway to your IP strategy. Here, one type of searches is prior art search. It's really important to know what's out there already before you invest money, effort, and time into a project. It's always frustrating, and it's really not that uncommon for someone to engage in R&D efforts and then decide to seek patent protection, only to find that there is an older patent which covers something very similar or even identical in some situations. So it's important to do prior art searches, which will help you to shape your IP and patent strategy. And when it comes to commercialization, and I would love to hear Lisa's perspective on this point as well. Having a granted patent doesn't provide you with a legal right to go ahead and commercialize your patented invention without ignoring other people's patent rights. So often we say patent rights are negative rights. So I'm not entirely sure whether it's a shield or a sword at this point, but the gist of it is you can rely on your patent to stop another person from commercially exploiting your invention, but it is not a shield to say, oh, look, I have a patent, therefore I'm able to practice my invention. So an effective IP strategy, in my mind, is to have, as you know, in terms of appropriate searches, to have those searches done so that you know what other people have done in the past, and you will also know what your competitors are doing. So it's important to gain competitor intelligence so that you can analyze the results, and the results will provide some reassurance around freedom to operate. Another search is called IP landscape search. So again, that's sort of the competitor intelligence you're trying to gain. So Lisa talks about COVID-19. It's just such a relevant example. Many players are in that space right now. So COVID-19 in that space this COVID-19 space is likely to be quite crowded. So it's important from a business perspective to understand and to navigate what IP rights other people may have, because their IP rights may impact on your commercialization plans. So Lisa, going back to you, do you think patent rights are a shield or a sword?
Yeah, well, I mean, it's to tie in what you were saying about searches, it's important to do your own independent search. Of course, when you're going through the patenting process, various patent offices will also conduct their search, but they're not necessarily perfect. And having your own understanding is very important in the sense that, if you have a granted patent and you want to assert your patent against a competitor who you believe is infringing, you don't want them to be able to turn around and say, I don't think your patent's valid. And in fact, I have this piece of prior art to show it. So understanding your competitors' patent landscape, what they are doing, what direction they seem to be headed in, that can help you develop your IP strategy as well, in terms of whether to file or whether to maintain your technology as a trade secret. And I think what this all ties into is our fifth tip, which is matching your IP strategy with your business goals, and making sure that what you're protecting via patents, what you have consciously decided to keep as trade secrets, how is that aligning with your business goals and the direction that your business is headed in terms of product pipeline? Are you going to go out looking to sell your own products, or are you going out to look for potential licensing partners and collaborators? The life sciences sector is extremely investment intensive. Many companies, in order to grow, do need to reach out and establish these collaborative relationships, and having a robust patent portfolio is very important for that. Or for certain aspects of technology, keeping it all in-house, you're able to manage that, and you have sufficient capital to move forward. In terms of matching IP strategy and business goals, what do you think of that tip, Jade?
I agree with you 100%. There's one of my favorite books is The 7 Habits of Highly Effective People. And I think for our audience who manage or who are involved in life sciences in the sector, I think many of you will echo, or probably you have read the book, and you will recall that habit number 2 is to begin with the end in mind. I think I use that mantra not only in my professional life, my personal life, but I also think that makes so much sense when it comes to the development of an IP strategy. I think we mentioned many times the development of an IP portfolio is time intensive. It costs money. So often the reward from IP protection may not be obvious at the beginning. At least it becomes obvious, the day where a potential investor walks into your lab who may be interested in investing, or a competitor files for patent protection, which may eventually interfere with your business operations. So I think really, when we think about IP strategy, we do want to begin with the end in mind. So it's important to plan ahead. Once you know where you want to be in 5 years or even 2 years, and then it's easier to come up with an IP strategy which match your business identity and to help you achieve your business goals. So Lisa talked about different examples. Perhaps I can add another example. So here, if a company's brand is to foster innovation and to engage in collaboration with different entities, perhaps for that company, their IP strategy would have a major component involving patent protection. And perhaps this is because at the end of the day, patent protection, it aims to encourage disclosure of everyone's innovation. So everyone else can come in and collaborate and create more knowledge and share that knowledge through licensing, cross-licensing, and other means of collaboration. So begin with the end in mind, think about your corporate identity, and then it will be your IP strategy will follow.
Yeah, I think that's a great way to end our discussion today of our 5 tips. So thank you everybody for tuning in. If you have any questions about what we talked about today, or any other questions relating to IP, please feel free to reach out. And thank you very much.